And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this live legal education content. Today is the day I earn that subscription. We are here with a group of stories that we are going to be recording and releasing tomorrow. So that will be exciting and fun. With different lighting, which is also exciting and fun, because I'm experimenting with different things, including different lighting and different recording and all the rest of it, trying to figure out what works best. And one of the best ways to learn is by doing and seeing what happens. Right? It's like you don't have to guess that way, right? Just try something and see what happens. And so we're going to do that. That'll be fun. Great. All right. So let's go now. I'm interested to see how this green lighting looks on camera, because I haven't had a chance to see how it looks yet on camera. So let's see how this looks. I don't know. So I don't know if I like that or not. We might give it a try. Let's give it a try right now. All right, so let's go ahead. Yeah. For those of you who are curious, this is green split complementary, is the color relationship between the various elements on screen. Exciting, fun. All right. Let's see. The LED is clicking in the background. That's going to bother me. Let me fix that real fast. I'll be right back. Hold on. Okay, that's better. Yeah, so there was an LED plugged in, and of course, refresh was causing it to blink, and that's not good. All right, let's go ahead and get started with the story. For today's story, we are covering a case that is being asked to be heard by the U.S. Supreme Court, dealing with the fact that people that are born in American Samoa, despite being a U.S. territory, they are not considered natural-born citizens. It's the only part of the United States that you can be born in, and you're not considered a United States citizen. And there is a challenge to this currently pending before the United States Supreme Court, and the Biden administration has asked the U.S. Supreme Court to not take this case. So they would like the people that are born in American Samoa to remain not U.S. citizens. Okay, so let's go ahead and read this. The Biden administration has told the Supreme Court it should not take up a case about citizenship rights for American Samoa, even though advocates say it would give justices a chance to upend a series of century-old precedents that have been roundly denounced as racist. Now, one of the big problems that's in play here is something called the insular cases. This deals with U.S. territories generally, and says that U.S. territories, the full Constitution doesn't necessarily apply to U.S. territories. And so whether or not it does or does not depends on specifically what kind of territory it is. It also means that the full Bill of Rights doesn't necessarily apply to U.S. territories. So the constitutional law that applies, for example, in a place like Puerto Rico, despite the fact it has 3 million U.S. citizens, and incidentally, being born in Puerto Rico does make you a U.S. citizen, so 3 million U.S. citizens, but the Constitution doesn't necessarily fully apply to a place like Puerto Rico because of something called the insular cases. What's interesting about it is when the insular cases were decided, in the text of the law decision itself, it said that this decision should only stand for a time. But as they say, there's nothing as permanent as a temporary solution. And so despite all these years later, the insular cases are remaining well in place. And of course, there have been calls to reverse the insular cases because of these reasons. And the insular cases screw over territories to varying degrees, including, perhaps most prominently, as I've been mentioning, American Samoa, which, despite the fact that they're born on this U.S. territory, are not considered U.S. citizens because that's how deep it goes. And so people are like, maybe these insular case thing, maybe that's not so great. Maybe we should take another look at that. But the Biden administration doesn't want to take a look at it for some reason. Okay, let's read more. The Solicitor General has told the Supreme Court that an appeal court had been right to find Congress should make the citizenship decisions about those that are born in territories, and that the case would be a pure vehicle. Now, whether or not a case is a good vehicle speaks to basically whether or not this is a good case to decide the issue. There are a lot of cases the Supreme Court could hear to decide an issue, but not all cases are equally good to decide that issue. As a general proposition, the more simple the case is, the more better it is. The less it involves other issues, the less it involves complications. The more pure the legal issue is, the better. And so they're saying, well, this isn't necessarily one of these pure cases. Okay. As Gorsuch has already written, the insular cases have no foundation in the Constitution and rest instead on racial stereotypes. I mean, to some degree, that is a fair characterization of the insular cases by its own terms. And Gorsuch has said the time has come to recognize the insular cases rest on round foundation, and I hope the Supreme Court overrules them. So, yeah, I mean, there have been lots of calls to overrule these in recent years, increasingly so. So whether or not this is the case to do it or not, who knows, but yeah. The group's petition says that those are born in American Samoa are labeled second class by the United States government. I mean, that's kind of undeniable because on their passports it says they are nationals of the United States, but not citizens of the United States. So that's odd. So they're kind of equivalent to a green card holder in some ways, despite being born in American Samoa, a U.S. territory, and it's stamped right on their passport. And if they want to become a citizen of the United States, they have to go through an immigration process to become a citizen. They have to immigrate from the United States to the United States. So if that sounds weird, it's a little weird. That's the law right now. It's a little bit messed up. So yeah. Despite a high percentage of residents serving in the military in American Samoa, pound for pound is one of the highest reach. Let me try that line again. Join my gaming Discord already so we can get a game going, Runkle the Bailey. I'd be happy to join your gaming Discord. Would you be so kind as to send me a link to your gaming Discord, perhaps on Twitter? That might be a good place to send it. Or you could send it to my email or something. Or whatever. I would love to join your Discord. We were talking, I don't know how long you've been here, but we were just talking about American Samoa over here. Talking about the fact that if you want to be a citizen, if you're born in American Samoa, you're born in the United States, but you're not a citizen. So if you want to be a citizen of the United States, you have to go through immigration, which means that you have to immigrate from the United States to the United States. I'm assuming Canada doesn't have anything equivalent to this. You already sent me the link? I don't see a link. Send it to me again. All right, where was I? No. This is the fun part you missed. This is the fun part you missed. All right, so we'll cover this again just to blow Runkle's mind. All right, so the United States, as you know, is 50 states and D.C., but of course not just 50 states and D.C., because the United States has some overseas territories. For example, Puerto Rico would be the most famous of these. Puerto Rico is neither a state nor, of course, D.C. It is none of these things. It is a territory of the United States. And because it's a territory of the United States, it is governed separately by federal law. And there is a case called the Insular Cases from 100 years ago that says the Constitution doesn't fully apply to the territories of the United States. So they're in this weird state. Now, if you're born in Puerto Rico, you are a U.S. citizen. If you're born on the North Marianas Islands, you're a U.S. citizen. If you're born in the U.S. Virgin Islands, you're a U.S. citizen. If you're born in American Samoa, not so much. You are not a U.S. citizen. Despite being born within the territory of the United States, you are not considered a natural-born citizen. On your passports, they will stamp it, national, not U.S. citizen. And if you want to be a U.S. citizen, you have to go through immigration, which means, of course, you have to immigrate from the United States to the United States. So, yeah, that's finer points of U.S. law that you never knew about. It's fun and exciting for the entire family. The Dominican Republic is not part of the United States. The DR is a separate country. Okay. Yeah. You were just joking? Well, I robbed the joke then, I guess. Why am I having such trouble with it getting properly on screen? The American Samoa political leadership and its delegate to Congress apparently believe the current system is fine, and have filed a brief with the United States Supreme Court saying there's no consensus on the issue of citizenship, and any decision on the matter should not be imposed by the courts but negotiated through political process. The delegate to Congress, who, by the way, only gets a vote in committees and not on the floor because, of course, they're a delegate, they're not a representative, again, because they're not a state. So does Puerto Rico and the Marianas Islands and American Samoa have representation in Congress? Well, kinda. They don't have representatives. They've got delegates. And they can vote in committee, but not on the floor. Let freedom ring. But their committee member apparently has said, we don't want the citizenship very much. What? Okay. For 3,000 years on an archipelago 7,000 miles away from this court, the American Samoan people have preserved for American Samoa the traditional Samoan way of life, weaving together countless traditional, cultural, historical, and religious practices into a vibrant pattern found nowhere else in the world, their brief said. The American Samoan people, and I take right notice, American Samoan, American, but not, because not citizens, the American Samoan people have kept Samoa alive in part by preserving their unique political status. Really? Okay. The string of islands in the South Pacific has been a territory of the United States since 1900. This has been going on for a hot minute. The Supreme Court turned down a request to take up the issue a couple of years ago, but this time the court has sought the views of the Biden administration. They put out a call for the views of the Solicitor General, which is usually a pretty good clue that the Supreme Court is taking it seriously. When the Supreme Court requests the views of the Solicitor General, it happens quite frequently, and it's usually a pretty good sign they're interested. Doesn't mean they're going to, but it's a good sign. But the Solicitor General is all like, nah. So the administration's been under pressure from some of its usual allies in the civil rights movement to urge the courts to take the case, but not so much. They don't want to. There's the link I've been looking for. There's that link I've been looking for. Let's join the Breaking Waves Discord. Ooh, nice graphic. Okay. Ooh, shiny penny. Thus, that brings us to our end of this discussion about something you might not have known about America. It is a bizarre place with bizarre rules, where sometimes you're born in the United States, but you're not a natural-born citizen. This is the nature of, and it's been this way basically forever. And the political representatives of the Marianas, and the political representatives of American Samoa apparently wanted to continue that way for some reason. They like the not being citizens, and incidentally, they're not citizens of any other country. And they like the fact that if they want to be citizens, they have to immigrate for some reason, according to their congressional delegate. I don't quite get it, but that's apparently where we are. So this is a potential opportunity for the Supreme Court to take another look at the whole insular cases and maybe reverse 100 years of law that was on questionable foundation, that was only supposed to stand for a little while and has been standing for a century. And at least for a moment, that brings us the end of consideration of this case. Okay, that was a thing that happened. Okay. Let's change colors and let's change stories. I'm liking this plan. This is how I'm rolling. We're going to do different colors for different stories and see how that works. Then the real key will be, how do I choose which color for stories? Like, is this story this particular color? I don't know. It'd also be a good opportunity to find out what color scheme people like best by actually using it. Also give me an opportunity to see what I like by actually just using it, see what I like. You know, like a reasonable thing to do. Now let's do another one. A registered prurient offender has been indicted in a murder-for-hire plot against a 12-year-old, saying, quote, she needed to end up dead. I'm thinking maybe this guy, between being the registered prurient offender and trying to do a murder-for-hire plot against a 12-year-old, may not necessarily be the greatest person. Let's read more. A 28-year-old registered prurient offender from Rhode Island has been indicted for allegedly enticing a 12-year-old girl to engage in prurient activity with him and then hatching a murder-for-hire plot to prevent her from testifying. Oh, good. So he solicited this girl to engage with him, and then is like, this is a witness against me, and I'm already a registered prurient offender. This 12-year-old might testify against me. How do I solve that problem? Let me create a murder-for-hire plot. Okie dokie. A federal grand jury has returned a 3-count indictment charging Chandler John Carande with 1 count of enticement for solicitation for the engaging of the prurient acts, committing felony offenses involving a minor while being an offender, and use of interstate commerce facilities in the commission of the murder-for-hire plot. According to a press release from the Department of Justice, he is accused of repeatedly communicating with the minor female victim via social media beginning December the 3rd of 2021. The individual, who was posing as a 17-year-old on December the 10th, allegedly picked up the victim from her school and engaged in some kind of prurient contact with her. picked her up from her school, having solicited her on the internet. Previously registered prurient offender. The minor victim was discovered on the side of Jefferson Boulevard in Warwick approximately 4 hours later by law enforcement. Our gentleman over here who's behind all this, while in detention, apparently attempted to launch a murder for hire scheme aimed at eliminating the minor victim as a witness. While in custody, he communicated via telephone with another person. During these communications, he expressed intent that the victim be murdered and offered $200 in cash and equipment worth $1,500. It's alleged in the indictment that he told the other person the victim needed to end up dead because she was a witness. So yeah, this is just going just about as well as, you know, okay, there's just so many lessons here, and I think they kind of speak for themselves, but, you know, maybe not so much if you're a full-blown adult with the 12-year-old. Maybe not, having done that, solicit the murder. Maybe not using the prison's telephone equipment. Maybe not saying specifically you're trying to eliminate a witness to your crime, which incidentally is an enhancement to a murder charge. Okay. According to a report from Providence, Rhode Island, CBS affiliate, the person he spoke with while in detention was actually an undercover detective with the Rhode Island State Police, wherein he said, quote, "I've got a 12-year-old witness and she needs to end up dead. You okay with that?" The undercover detective was less okay. He has a history of prurient-related offenses dating back in nearly a decade. He was convicted in July 2014 on one count of first-degree child prurient offenses and one count of third-degree prurient assaults. If convicted, enticement is punishable by a minimum of 10 years. Committing it is in another 10 years. And interstate by murder for hire is punishable by a maximum of 10 years. So facing some time in prison relating to the child prurient interaction murder for hire plot thing. Okie dokie, let's wrap this up. Thus, that brings us to the end of the story of Chandler and John Cardente, 28, from Rhode Island, who claimed to be 17 and then picked the girl up and engaged with her and then tried to solicit her murder. It's going just that great over here in Rhode Island. And now the feds want a piece of him for, you know, all the things I just mentioned. So we'll keep watching that. And at least for the moment, that brings us to the end of the discussion of this story. Great. Next color. I guess it was appropriate that we had red on the screen for that one. That was not really intentional that we had the red, but I think it suited well for the story, so. Okay. If he was in custody, how'd he pick her up in the car? The custody thing happened later. He picked her up in the car. Things happened. 4 hours later, the girl is found on the side of a highway. The police then arrest him while in custody, solicits the murder. So sorry if the timeline wasn't quite clear, but that's that, yeah. All right, let's take a look at this. Anid Saeed. Adnan Saeed. Adnan Saeed. I'm trying to work on this name. Adnan Saeed. Okay, I think I got it. Okay. For today's story, a person who was the focus of one of the more popular podcasts in recent memory, season 1 of the podcast Serial, the suspect, Adnan, I can get it right. I can do it. Hold on, I'll do it again. Adnan, I can do it. For today's story, we are covering the story of Adnan Syed, who was the subject and focus of the entirety of season 1 of Serial, which at the time was one of the more popular podcasts that had been released. He was the focus of this wrongful conviction series that was done, and it was quite popular. And a couple years later, he has been released from jail as a Maryland judge has vacated his conviction after the prosecutors filed a motion asking for that because the prosecutors said they no longer had confidence in their own conviction. So Adnan Syed is currently free from jail. The prosecutors do have 30 days to decide whether or not to re-prosecute him, but let's cover what's happened so far in the story. Baltimore prosecutors had asked the Maryland magistrate to vacate the judgment in the case of Adnan Syed, whose decade-old murder conviction garnered renewed interest after it was featured in Serial in 2014. It was a very good podcast, incidentally. At least it was very entertaining. The reporters told a story. They told a very good one. I don't know whether or not there's counter stories to be had, but it was a very good podcast. I listened to it at the time. And so fast forward 8 years later, and the case, I think largely because of that podcast, he's now free. So the judge granted the prosecutor's request shortly before 4 o'clock. He had been convicted with a life sentence of killing his ex-girlfriend in 1999. Her brother told the court Monday he was not opposed to the release, but felt betrayed by how the prosecutors were handling it. So the victim's own brother apparently has enough doubts in his mind that he doesn't oppose the release at this point, which gives you a little clue as to how much the prosecutors must have completely fucked this up. $10 from Jennifer Foley, just because. Thank you very much, Jennifer, for your generous super chat. As always, all your financial support is extremely appreciated. Thank you. In an emotional statement, Lee told the judge he was not opposed to Syed's release because he has faith in criminal justice and the court, but he said the motion to vacate blinded him and left him shocked. Apparently, they only gave him 2 days' notice because of this surprise motion. They only gave him 2 days' notice, and he lives on the opposite coast of the United States. And he wanted to appear in person, but they wouldn't give him time to get there. So he felt a little bit hurt by that. That, you know, he only got 2 days notice on the whole thing. I'm not against this release. I'm kind of blindsided. I always thought the state was on my side, but out of nowhere I hear there's a motion to vacate. I thought, honestly, I felt betrayed. I mean, yeah, that's a lot to process in a very short amount of time. Hey, 48 hours from now, we're going to release the person we convicted of murdering your sister. How do you feel about that? That's not great. He said his mother was also struggling with the news. You think? This is not a podcast for me. It's just real life, he said. Never ending. After 20 plus years, I asked Judge you make the right decision. That's all. That's pretty gracious for him, to be honest. Feeling a little bit hurt by the prosecutors who 20 years after the fact, because it's a murder in 1999, so 23 years after the fact, are now just getting around to saying, we think we had the wrong guy all this time. Okay. Prosecutors highlighted several key pieces of evidence in their motion, including the possibility of additional suspects, one who had allegedly threatened to kill Lee, and another who's linked to an address where Lee's car was ultimately discovered. They also said that other possible suspects were convicted of crimes. We believe this is consequential information that needs to be reviewed further, the district attorney said. Prosecutors said they continue to plan their new investigation and asked the judge not to dismiss entirely. They also asked for Syed's release on his own recognizance for the time being. So, yeah, he's not, I guess, strictly speaking, completely out the clear, because the prosecutors get 30 days to decide whether or not to prosecute him again. And he's basically essentially on self-imposed home confinement while the prosecutors figure it out after 22 years. It's going great. The district attorney's office said that a year-long review uncovered the new evidence, and the state no longer has confidence in the integrity of the conviction. Yeah. The filing in Baltimore City Circuit Court revealed new information regarding 2 other potential suspects and found that DNA testing yielded mostly inconclusive results or no results at all. To be clear, the state is not asserting at this time the defendant is innocent, the motion reads. However, for the reasons set forth below, the state no longer has confidence in the innocence of the conviction. Well, how gracious for them. The report then goes on to note that the Serial podcast raised doubts and became the most downloaded podcast of all time, which I totally believe. It was extremely popular. And the investigations into his claim its innocence led to the hearing, which led to the attorneys challenging the evidence. So, yeah. So that's all the things that are going on. Thus, for the moment, that appears to be the end for Adnid Syed. It's 20 years later. He's been in prison on a life sentence for 20 years on questionable evidence, on questionable grounds, as was raised by the Serial podcast. And the Serial podcast itself happened 8 years ago. So he's almost been in prison as long as the podcast was out as he was before. 8 years and 12 years respectively. And they finally just said, hey, maybe the evidence against him is a little suspect. We're not saying he's innocent, but we're not confident. So they have 30 days to decide whether or not to charge him again, which after a year-long conviction, a year-long investigation, after 20 years, if they're not ready now, I think they're going to let it go. But they're not going to make that formal announcement, I guess, until the last minute. But that's what's going on in Maryland. The podcast... the podcast subject has been released, and at least for a moment, that brings us to the end of this discussion. Yeah. Great. Let's take a look at another color scheme. How are you liking this one? I guess it's pretty good so far. This is called Navy Blue Analogous. So the overhead light is navy blue, and then the lights under the cabinets and under the counter are the next closest lights on the color wheel. So that's analogous colors. Now we're going to try Blue Triadic, which is similar to the Navy Blue Triadic, but it's slightly different. So this is, okay, so this one was Navy Blue Triadic, a little darker. And this one is Blue Triadic, a little brighter, basically. Although strictly speaking, it's not brighter, it just has more perceived brightness because of how colors work, but never mind. Okay. Any lighting with purple? Actually, we do. We do have violet lighting. We'll get there. All right. A California mother who had faked her own kidnapping says the shame she feels like a life sentence. She's already been punished enough. This is the story of Sherry Papini. If that name sounds slightly familiar, she was all the rage for a hot minute when she was missing. It turns out that she faked her own kidnapping. She was sentenced today, incidentally, to 18 months of prison, which was more than the prosecutors had recommended. I guess the judge felt a little bit irritated. So we're going to read this article from a couple days ago, which was discussing her plea deal. But she got 18 months today. So let's go ahead and read this story. Here is a picture of Sherry Papini. In case you had forgotten the name, that's what she looked like. Okay, I guess still looks like technically because she's still alive, because it was all fake. The California woman who was awaiting punishment, it's 18 months, for faking her kidnapping in an admittedly awful hoax, said through her lawyer that her undying lasting shame already feels like a life sentence. Well, now you have a felony conviction, and you're serving 18 months. So yeah, Sherry Papini, 39, who was heading for divorce, pleaded guilty in April to making false statements and mail fraud in connection with her disappearance. Her attorney said in a sentencing memo that she should be sentenced to a term of no more than 8 months with 1 month in custody and 7 months for home detention. The judge was not buying that recommendation. It's like, no, I don't think so. In part of the argument, they suggested the client had already been punished plenty in the court of public opinion for her year-long lie. Oh yeah, that's how criminal justice works. If you're sufficiently punished in the court of public opinion, then we don't have to actually punish you by sentencing you to prison. Is that how that works? Oh, I've already had my reputation hurt. Why? Because the awful things I did. Oh, okay. All right. Miss Papini maintained the lie for years, terrified she'd actually destroyed the one thing in her life that brought her true love and happiness, her family. Desperately praying that the day of discovery would never come. Once discovered, she lied again until there was nowhere else to go but admit to the truth, the defense wrote. That is not exactly the most encouraging defense argument I've ever wrote in my life. She's a liar who lies. When caught, she lied. She lied until she could lie no more. She did her best, but eventually the lie came down. But she tried. Okay, I don't know that's necessarily the best defense argument I've ever heard. That day of reckoning has arrived, and anyone who cares to read about it knows the deepest, darkest depths of her sick mind. The most shameful part of it is now it's a matter of public discourse, and she sees that knowledge every day in the eyes of people that she encounters, who think maybe she's a liar who lies, who would, try to fake her own kidnapping as part of a divorce strategy. The real pain is knowing the hurt she's caused so many people, and she must spend the rest of her life trying to repair the damage she's done. Following the guilty plea, the feds signaled they'd recommend a low sentence. On Wednesday, they recommended a sentence in line with the defense. 8 months in prison with 3 years of supervised release. So the feds, for whatever reason, were feeling compassionate too. The defense said, how about 8 months with 7 months release? The feds said, how about 8 months with 3 years release? The federal judge is like, nah, I don't like any of those numbers. How about 18 months with release? That's one of the things. Is like, yeah, the judge doesn't have to pick either number. He doesn't have to meet you somewhere in the middle. It's one of the things the judges get to do with sentence. It's like, well, I'm not sure how you guys came up with 8 months. How about 18? Because I'm the judge. Yeah. The prosecutors made a point to show how far the lies went in the hoax. On August 13th of 2020, after law enforcement had evidence showing Papini had not been kidnapped, a special agent of the FBI and detective of the sheriff's office met with Papini. At the outset of the interview, they were warned it's a crime to lie to federal agents. Now, this is something that the federal government does because they want to make sure that you're aware that you're knowingly lying, because the statute, 18 U.S.C. 1001, which makes it a crime to lie to the federal officials, right? It has to be knowingly, intentionally. And so one of the things the feds will do to make sure that you are doing it knowingly and intentionally is they will tell you. They will read you right? So it's like, basically, I'm telling you that lying to a federal official is a federal offense. And anything you say after this could be used in that way. So do you still want to lie to me? If the FBI ever say this to you, you should shut up. Although you should have shut up long ago, to be honest, because you shouldn't be answering any questions from the FBI, because when they come to you and say, can you ask a few questions? What you should say is, I don't want to talk about my day, officer. But this is like kind of like a Miranda warning. If you've gotten this far, you're already effed up. It's time to stop talking. Does she stop talking? Nope. She was also told about DNA and telephone evidence showing she had been with her ex-boyfriend. So not only was she told it's a crime to lie to the FBI, 18 U.S.C. 1001, but she was told, we think you're lying because we have DNA and telephone evidence that shows you were with your ex-boyfriend. They told her this. Yet even after this warning and evidence, she continued to lie. This is how they show a knowing lie. This is how they make their case. They've warned you. Now they tell you why they think you're lying. And now you're going to lie anyway. This is how they do it. She not only made false statements to law enforcement, of course, but her friends, family, and therapist, but also made false statements to the California Victims Compensation Board and the Social Security Administration in order to receive benefits, which would be fraud. Hence the mail fraud thing. Yeah. According to the original criminal complaint, Papini's husband used a cell phone tracking system to locate his missing wife's phone and earbuds. She left her phones and earbuds like just on the street for him to find as part of facilitating the kidnapping. Now, why they'd be left behind in just like a nice little pile, who knows? But that's what she went with. Weeks later, Papini emerged after the kidnapping that never happened, weighing 87 pounds and claiming two Hispanic women had abducted her at gunpoint, and her ex-boyfriend was involved. So, yeah. The ex-boyfriend told investigators that Papini stayed with him at the house during the dates of the disappearance, and was Papini who reached out to him and asked to come over to pick him up. DNA evidence recovered from the clothing she was wearing when she returned matched the ex-boyfriend's DNA. So the ex-boyfriend says, it wasn't that she was kidnapped, she was at my house, and she wanted to be there, and she asked me to do that, and we found his DNA on your clothing. So you sure about those two Hispanic women, Miss Papini? Yeah. Phone records show Papini and the ex-boyfriend were talking to each other as early as December of 2015. She wanted to cheat and escape with her ex-boyfriend, who I guess just dodged the biggest bullet ever. And rather than just do that, she faked a whole kidnapping thing. The investigators, the ex-boyfriend had told investigators that they used prepaid phones to talk to each other, and this was corroborated through two prepaid cell phones that were tied to the ex-boyfriend and communicated with each other. One from Papini's location, other from the ex-boyfriend. So it's like, oh, we used throwaway cell phones, but we didn't, throw them away as much. We could still correlate the phone records. Like, yeah. The FBI went so far as part of the investigation into the fake kidnapping thing as to employ a sketch artist to draw up composite images of the non-existent attackers. So they asked Papini to describe the attackers, and apparently these were the two attackers that attacked her, but of course they don't exist. So Papini is just using her very rich imagination as part of this whole I want to cheat on someone with my ex-boyfriend fake kidnapping plot as part of a divorce. Yeah. Thus, that brings us to the end of the case of Sherry Papini, who today was sentenced to 18 months, which was more than either the defense or the prosecutors wanted, because the judge is not bound by the sentencing recommendation of either the prosecutor or the judge or the defense, right? Even if they agree, it's not bound by it. It's one of the things judges get to do is have sentencing discretion. And it's like, how about 18 for this incredibly rich murder, fake kidnapping, fake whatever plot that you put together, and cost resources and time, and we need to send a message. So Miss Papini has been sentenced to 18 years. She is a felon. And that, for the moment, brings to the end of discussion of this story. Outstanding. All right, so that was blue triadic. Now we're going to go to blue analogous. All right, so let's compare that to navy blue analogous. So that's navy blue analogous. You can see the different colors. It's perceived darker. And then you get blue analogous. That's also pretty cool, I think. I have to be honest, I'm kind of liking the rotating colors for the story thing. I'm not set on it. I'm not saying I am or am not doing anything. I'm just expressing my thoughts in real time. I'm kind of liking the different colors and just rotating colors through stories. It's another way to visually distinguish the stories, in addition to visually and the thumbnails, right? And visually distinguishing the thumbnails by using different color schemes. So you like this one? You like this one? You like this one that's got the purple in the background? And obviously you could switch the colors, right? You could switch the colors between the background and not, right? So the only thing that's really fixed is the overhead light, because the other colors are dependent on that. But like which one goes in the back and which one goes in the foreground is just kind of up in the air. So the three colors are fixed by their color relationship, but where they appear is up to it. You should create some routines so you can easily transition. I don't know, man. Pressing a button like I just did just now is pretty easy. I mean, I just have to look down for half a second and press a button. And it's pretty easy. Let's see what else we got. I don't want to do that one. You need to get a disco ball and call it a day? How's this working? Is this good? How's this working for you? Yeah, we weren't really going to use it for filming. Jones was like, you should just put it on a disc ball. I'm like, okay. I mean, I'm obviously not going to use it for filming. Do those switches, like the movement in the background, cool? Do those switch automatically like that? Yeah, they do, of course, switch automatically, yeah. Okay, let's do this. Yeah, there are other like color schemes in there too. That one's obviously called Party. There are other color schemes in there, so all kinds of fun options. A white professor has filed a discrimination lawsuit against Texas A&M, arguing that affirmative action policies prevent him from getting a professorial job with tenure because he is white. So arguing that there has been racism as applies to him, discrimination on the basis of his skin color. All right, let's go ahead and read this. In a class action lawsuit filed September the 10th, the University of Texas Austin associate finance professor Richard Lowery argues that Texas's A&M's hiring policies favoring underrepresented minority groups exclude whites and Asians. So he currently has a job at the University of Texas in Austin. He would like to apply for a position at Texas A&M, but he has some problems, he says, because of race. His lawsuit has asked a federal judge to declare the university's race and sex-based preferences to be patently illegal under the Civil Rights Act. The complaint cites Title VI and Title IX of 1964, which prohibits universities from discriminating on the basis of race in the case of Title VI, or in the case of gender in the case of Title IX. So this is a lawsuit that's interesting, and there is currently before the U.S. Supreme Court a case dealing with this issue as it relates to student admissions. Students for Fair Admissions versus Harvard is being heard this term by the U.S. Supreme Court. It's being heard this fall, I believe. I forget exactly when. It's either like October, November. It's earlier in the session, so it's coming up pretty soon. And dealing with race-based preferences or race-based advantages by public universities, which has been permitted since a case, ironically perhaps, coming out of the University of Texas Austin. The current case law that allows for colleges to use race in some sort of preferential race was a case called University of Texas versus Fisher, which is the current case law. But the Supreme Court is rehearing, basically, University of Texas versus Fisher. And all indications are, of course, the U.S. Supreme Court is going to reverse University of Texas versus Fisher and say that race-based preferences, race-based advantages, race-based discrimination is unconstitutional because because of, for example, Title VI and because of the Constitution. So this professor is adding to that chorus, and one would imagine his issues would turn on the Supreme Court's decision in Fisher, or the Fisher successor of Students for Fair Admission, and we'll see how that all pans out. Both the University of Texas in Austin and Texas A&M are public research universities. With more than 70,000 students, and that is a lot, Texas A&M has one of the largest student bodies of any university in the nation, the largest student body. So, yeah, apparently Texas A&M with 70,000. I mean, damn, I went to Clemson, which has a total student body of, I think, 23,000. So that's like, it's 3 times as many. That's a lot. The vice chancellor of marketing for Texas A&M said they will review the lawsuit and take appropriate action as needed. And then they have this little quirk in there, this little quip, by saying it's an unusual job application. When Mr. Lowery says in the lawsuit he's able and ready to apply for a faculty appointment. So they're giving a little dig there. Thus, that brings us to the end of the discussion of the story of the white professor who sued for racism. He argues that because Texas A&M has preferences for people of particular races, that necessarily is a non-preference for people not of those races. To benefit someone necessarily is to prejudice someone else. If you're not giving everyone everything evenly, if you're giving someone a benefit, you necessarily have to do it at the expense of everyone else. Otherwise, it's not a benefit. And he argues, well, that's discrimination on the basis of race. They are, by their own terms, giving preferences to people who are particular races, particular minorities. And that's illegal. And the case law on this, as I've mentioned, at least in admissions, is governed by University of Texas, Austin versus Fisher. But it probably will be governed in the future by Students for Fair Admission versus Harvard, which looks to overturn race-based preferences of any kind. So we'll see how that all pans out. Should be interesting, and that for the moment brings us to the end of discussion of this case. Fun. Next color scheme. All right. Let's see. Okay, what else we got? Don't want to do that one. Okay, I'll do this one. And I'll do this one. So I got 2 more. You guys want to go to the violet? Because someone asked me about violet. Or do you have any purple? Yes, I do have purple. You guys want to go to violet? Let's do a violet one. That's Azure Triadic. So let's skip the Asher ones and go to violet. Violet Triadic. All right. You love this one? You like this one? Showing the increasing power of DNA evidence, a man has been arrested after a son's DNA provided a link to a 50-year-old cold case murder in Hawaii. So the son gave DNA, I believe, to, and let me redo the intro because I believe it was... It just says the authorities obtained a DNA from him. It doesn't say how. Maybe they asked. Don't give your DNA to the police. Let me redo this introduction. You say it's good for my skin and I'm pronounced in the background? Looks like a beach sunset in the background. I can dig that. Okay. Showing the increasing power of DNA, including by familial DNA, a man has been arrested after a son's DNA provided a link to a 50-year-old cold case murder in Hawaii. So this is obviously of increased interest after the whole Golden State Killer. As many of you might recall, the Golden State Killer was captured because one of his relatives had their DNA inside of one of the databases for like 23andMe that the police had access to. And because of that, they were able to determine a familial DNA match, which then led them to the Golden State Killer. And then they got his DNA from, I believe, if memory serves correctly, like a disposable cup. They followed him around until he threw out some garbage he had touched or something. And so that was the use of familial DNA. And in a similar case, to some degree, a man has been arrested and charged after his son's DNA provided a link to a 50-year-old cold case. So going to show how DNA is being used in the modern world to cure and solve cold case crimes. So let's go ahead and get started with this. Here is a victim. I apologize, let me try that again. Here is a photo of the victim, 1972 victim Nancy Anderson. So her murder might have just been solved. Anderson had been stabbed multiple times in her Waikiki apartment in Honolulu. Anderson's roommate woke up on the date and heard water running in the bathroom. The door was ajar. The roommate pushed the door open and saw the body on the floor. Neither the roommate nor any neighbor said they heard anything suspicious, and there were no known witnesses to the slaying. Blood was located on the bathroom floor, on Anderson's bed, and on the floor where her body was found. Bloody towels were also found where the killing was occurred. Police interviewed a dozen people, but the investigation went cold, and there were no viable leads found. In the summer of 2020, the Honolulu Police Department partnered with a Reston, Virginia company called Parabon Nanolabs to develop a sketch of what the suspect might have looked like based on DNA that was recovered from the scene. So they had an unknown person's DNA in their files from the 70s. They processed it. No matches. And they partnered with this company to try to build an image of what this person might look like, to predict a person's physical appearance and ancestry from the unidentified DNA evidence. So interesting police tactic there. Try to get an image, maybe match him against someone that they might have an image for who might look similar in their files. Using the DNA evidence that was recovered from the investigation in the 70s, Parabon produced trait prediction for a person of interest. Individual predictions were made for ancestry, eye color, hair color, skin color, freckling, and shape. By comparing these attributes, a snapshot was done of what the person might have looked like at 25. The analysis revealed that the suspect was likely a mix of Southern and Southeastern European heritage, had brown or hazel eyes, fair or very fair skin, and likely had brown or black hair. And here is a picture of what the DNA evidence profile suggested the person might have looked like at the time. Now, of course, they don't know the person's age, but they're making an intelligent guess, right? They're guessing the person's of roughly the same age of the victim. You know, it was one of her friends or associates or something like that, which is a reasonable assumption. So they're like, okay, let's pretend this guy who did it is of the same age. What would he look like? Here's what they came up with. A Honolulu ABC affiliate reported that there was a person who was first identified as a potential suspect in the murder back in 2021. They then say that the authorities obtained DNA from the suspect's son, which then became a familial match. So presumably went up and asked him, can we borrow your DNA for whatever reason? Apparently said yes, and then his son's DNA matched. So then, based on the match, they obtained a search warrant for their suspect's DNA, and there was, in fact, a DNA match. So that brings us to the end of this discussion of this story about this DNA match for a murder that had occurred in 1972. Someone had gone away with this for a very, very long time. And I wonder how many elderly people are in old person's homes right now shaking in their boots. Because I've heard tell from like convalescent nurses, the number of adults, the number of people, of old people who will confess to like casual murders would astound you. I wonder if any of them wonder if they'll ever get caught now, because DNA is becoming more widespread. People are giving their DNA more and more to these databases. The government is being able to use them more and more as part of familial matching and solving more and more crimes with them. So it presents some interesting stories, to be sure, in criminal investigations. Things that we long thought were over, but now maybe we can figure out who did it. So an interesting step along the way, and at least for a moment, that brings us to the end of the discussion of this story. All right, let's do one more. Laura becomes a member. Thank you, Laura. And thank you, Texas Carlulu. All right, so that was Violet Triadic. And then because you like Violet, I got Violet in your Violet. All the Violet, right? We can do Violet Analogous. So instead of being opposite from each other on the color wheel, they'll be next to each other on the color wheel, which would look like this. I don't know. I'm not sure that's different enough. I'm not sure there's enough distinction between those colors. What do you think? And it kind of undermines the problem I'm trying to solve in the first place. Got a black light? I do not have a black light now. Pretty monotone? I agree. It's kind of monotone. Okay. This was the one I think we started with. Let's see, let's go back to Azure analogous. Let's go back to Azure triadic. Azure analogous. Let's do that. What about greens, limes, green and blue? We did green. We did green to start with, which actually worked out pretty well, I thought. We did green. We did green triadic. You like the 90s? All right, let's do this last one. Okay, so this will be interesting for tomorrow. So here's what I think I'm gonna do. Just in terms of like releasing these. So I'm going to probably make this video unlisted, but I probably won't make it private. Just in case anyone really wants to rewatch it, so it'll be in their feed. Although I might make it private, I don't know. Maybe I will. Maybe I'll make it private, maybe not, I don't know. But either way, my plan is to edit these and release them all tomorrow, I think. One of them might not make it, but this is kind of like my working plan in terms of filming and stuff. Like I've been playing around with things in terms of like filming schedules. And here's what I'm thinking. And let me know if you like this idea. So here's what I'm thinking. Okay, every evening I will record a number of stories. How many stories? It will just depend on how many are interesting, right? Because I don't know, got like 12 stories, and as I was reviewing them, dismissed some of them because like I don't want to do that story. Like, so I highlighted some, and then I didn't, and then I wound up like doing 6 of them, or whatever it was. Of the 6 I do, maybe not all of them will make them into the final edit. So maybe I'll release all 6, maybe not. But on like any given day, I'll release as many stories as there are. Like, so some days it might be 3, some days it might be 6, right? And so every evening I would film, and every day I would then edit, and then I would release them at some regular intervals throughout the day. So let's say I film every evening at, say, I don't know, 6 o'clock, 7 o'clock, my time. And then, so I would post, like, say so I'll post a story at 5, and then post a story at 3, post a story at 1, post a story at 11, post a story at 9. Like, do something like that. Like, do like 2-hour separations or something. Could be good. So that's kind of what I'm thinking. And it would be interesting. And then we'll just be however many stories there are that day. And then also it means I can film shorts in the morning. So I would edit them in the evenings and early morning, and then I would film a short for each one for my shorts channel, which I would upload to TikTok and YouTube Shorts and Instagram at the same time-ish, around the same time as the other stories do. I don't think the timing is as important for the shorts, but I would release those throughout the day too, so they would relate to the stories that went that day. And hopefully between all that would gain some additional interest and subscribers for the channel. So some of you like the long form. Okay. Can you make it members only, then private after editing? Maybe. And the problem, yeah, maybe, I don't know. The issue is just like, there's a couple issues, but one issue is just it steps on my content. I like having you guys here to film. How many people are here right now? So 200 of you? So there's 200 of you. The problem with leaving it up in long form is that it's up in long form and people will find it. And then it steps on my stories, right? So I could film it completely offline and then it won't step on my stories at all, right? So if I just filmed it without me being here, then it wouldn't step on it because you guys wouldn't have seen it until it's released. but I kind of like you. I kind of like you guys being here, and I kind of like interacting with you, and so then I can do it this way. But if I leave the thing up, then it becomes an issue where it might step on my own content. So this is kind of the issues I'm playing with. So we'll see how it's going on. And I do like interacting with you guys. So we'll experiment with different things. You're going to do empty room videos? What is an empty room video? Am I going to do empty room videos? What's an empty room video? I don't understand. I don't know what that means. Nobody there? Why would I do an... I don't understand. Why would I film a story with no one in the room? Why just take video of the room and just empty? Why would I do that? That doesn't make any sense. Just the room? I don't get it. What happened to Kurt's bar exam? Kurt is still waiting on bar exam results, and I won't know until October. Some states have released results already. I saw Florida released its results, I think, today. Texas has not yet released its results, so I don't know yet. Sometime in October. They haven't told me an exact date. All right. What am I going to do when I pass the bar? Nothing. It's meant just to preserve options for the future. I have no intention of giving up full-time YouTube for passing the Texas bar. It's really just there in case I need it. It's just there as it's a way to preserve options for myself going into the future. It's a nice to have. I'm not planning on changing anything about how I film. How the hell can it take by this long? Because a lot of it has to be graded by hand. The essays have to be graded by hand. Someone has to read those things. It takes time. All right. My friends, there has been much controversy over the issue of pronouns and people choosing their own pronouns and all the rest of it. But one man has taken his displeasure for this to the next level because he's been arrested on charges of threatening Merriam-Webster, the dictionary, and other people, incidentally, because he didn't like their definitions relating to gender identity. I understand the frustration on some level, but as always, maybe less with the threats for things you don't like would be great. Let's cover this story. The man, who is Jeremy David Hansen of Rosamore, California, was arrested for threatening to kill every employee of Merriam-Webster. He was charged with 1 count of interstate communication of threats to commit violence. He's set to appear in district court on April the 29th. From October the 2nd until October the 8th of 2021, Hansen, who is 34, sent anonymous messages, and not so much anonymous because we know who he is, to Merriam-Webster, who publishes one of the more widely used dictionaries, condemning the company for changing the words of boy, girl, and trans woman. Now, you can, of course, express opinions about this, including to the dictionary, but maybe not so much with the threats. There's no such thing as gender identity, he wrote in a comment. That would be fine. The imbecile who wrote this entry should be hunted down and shot. We're getting into sketchier territory. That can be a problem. Hansen then escalated the threats from there, sending messages saying the company's headquarters should be shot up and bombed. He wrote that by changing the definitions, the company was taking part in efforts to degrade the English language and deny reality. Yeah, I did incidentally read the indictment against him, and he made quite a lot of threats against quite a lot of people. Yeah, he has some very violent things. This story is not really telling the half of it, to be quite honest. He told quite a lot of very aggressive things. In October, Merriam-Webster reported the threats to the FBI, which tracked Hansen through his IP address. Which brings us to today's sponsor, NordVPN. Which, no, I'm not really a sponsor, maybe later. Also, incidentally, please don't send the death threats. I can't say that. I've got to cut that part out. Wow, I got to cut that part out. That's just not, that's going to get me in trouble with NordVPN, ma'am. Okay, let's try that again. In October, Merriam-Webster reported the threats to the FBI, which tracked Hansen through his IP address. Because of the threats, the company closed its offices for 5 days. You had me for a sec. Yeah. In recent years, Merriam-Webster, the country's oldest dictionary, has updated certain definitions to be more inclusive of shifting attitudes. Yes, it is true the dictionary is definitely doing social justice work. They including updating their dictionary in real time to embarrass Amy Coney Barrett. Amy Coney Barrett was asked about the phrase sexual preference, and Senator Hirono of Hawaii, this is during the confirmation hearing, by the way, Senator Hirono of Hawaii said the term sexual preference is offensive because it implies a person has the ability to choose, and they don't. And she's like, well, I didn't really know that, but okay. And that day, Merriam-Webster changed the definition of sexual preference in the dictionary to indicate it was offensive. The dictionary didn't say that before, but once Senator Hirono said, oh, it's offensive, Merriam-Webster literally changed the dictionary that day in real time just to try to embarrass Amy Coney Barrett. It wasn't offensive earlier that day, but it was then. Okay. Hate-filled threats and intimidation have no place in our society. Prosecutors said while they were investigating Hansen's messages, they found threats against others. Yeah, I read the indictment. There's some stuff, including against the American Civil Liberties Union, Hasbro, Land O'Lakes, the Butter People, and New York Rabbi and others. I read some of the statements in the complaint. He has what seems to my mind to be some anger issues. I don't blame the prosecutors for thinking that he's reached the true threats category based on a more full explanation. It's a lot. He has some anger control problems. Everyone has the right to express their opinion, but repeatedly threatening to kill people takes it to a new level. Yeah, he not so much. So don't do that. Thus, that brings us to the end of the discussion of the story of the man who called the dictionary, and quite a lot of other people, incidentally, to make threatening messages because he didn't like the wokeness. Again, I understand you not liking the wokeness. I understand you're being frustrated at this. I understand being frustrated at the fact that they're changing definitions in a way that doesn't even make sense, by the way they change definitions. It doesn't even, like, because the new definition of female is just someone who identifies as a woman, which doesn't help you because what? But okay. Anyways, so I understand the frustration, but maybe not with the death threats. So don't do that. And that, for the moment, leads us to the end of discussion of this case. Yay. So that is the end of all that. I know you're excited. I am too. So I need to start editing, so I don't have very long, because I need to do some editing tonight to try to make sure that I, get this stuff up tomorrow. But I think this is workable. I think this might be workable. I might need to start recording earlier in the day so I don't blow my evenings away. I might need to find like a better time to film. I might need to find a better time to edit, but I think this might work as a strategy. We'll see. We'll play with it and we'll see what happens. Kurt, you should consider covering the Charlie Alderson trial. Oh, the FSU law professor? That's actually not the worst idea, because I've heard that before. What's going on with that? When is his trial supposed to happen? That's a possibility. Let me take a look at that. No trial date has yet been set. Okay. Early next year. Depending on timing, that could be challenging. If it conflicts with, Daybell, obviously, Daybell's going to win. Yeah. Oh, poo. Ending so soon? I've been here for an hour 20. We didn't need that much time. And if I edit and stuff and get done at a reasonable hour. So, yeah, this could work. This could work as this thing. Are we no longer watching the Alex Jones trial? Probably not, Brenda. Yeah, I think the answer to that question is just no. The problem with the Alex Jones trial is twofold. But they all basically boil down to opportunity cost. Is the problem with the Alex Jones trial. The Alex Jones trial was just not bringing in enough people. It's all day. It's all day. It's 8 hours. It's 9 hours. While there was some people super chatting, obviously, it wasn't very much. And I don't begrudge anyone for their super chatting or not, obviously, but I want to produce content that will encourage more people to donate financially, because this is now my job. This is my job, and I need to produce content that's going to be as widely received as possible and help the channel grow. The problem with covering something like Alex Jones all day is opportunity cost. Because it's time I am not doing something else. Namely, for example, what I just did just now, right? I can't do this if I'm doing Alex Jones, because when am I going to release the stories? I can't release the stories because I'm already covering Alex Jones all day. So it becomes an issue. It becomes an issue of, what do I think? And it's all guessing, right? It's all trying to make an intelligent guess, but it's like, what do I think is going to be better overall for the channel and growth? It's like, do I think overall it's going to be better for the channel and for growth to do Alex Jones every day at the expense of basically everything else? Or do I think it's going to be better for the channel and growth to do 4, 5, 6 other stories and release them throughout the day? And so that's sort of the calculation that's going on in my mind. It's like, what's going to be best for overall growth and interest in the channel? And so that's how that's going on. So I mean, that's the calculation. The thing is, I as a channel, I'm a legal education channel, and there's essentially infinite stuff for me to cover, because there's a lot of law every day, right? There's these kinds of stories which are a little bit more pop, which I think is also an interesting direction. I could also just troll. I can just troll the courts of appeal. It's like, if I need something to cover on any given day, no problem. Just troll the court of appeals, right? Just go pull their dockets and their opinions that they released that day. There's always something interesting there. So I could do courts of appeals decisions. I can do historical decisions. I can do ongoing trials. There's basically infinite things for me to do. And I love talking about all of it. And then the question just becomes, well, okay, what is the most productive for the channel? what's going to help the channel grow the most? What's going to help the channel be, you know, what it needs to be? So that's what's going on. I could do a wrap through the day. The problem with doing a wrap for the day is I still have to watch it to do a wrap, unless I'm just trying to rely on some article that was written by someone else, which I could do, but it's not ideal. Joshua gave $9.99 to say, I just wanted to see the conviction of the guys who shot the clerk in Mississippi. I love the lights. Thank you. And Michael Melvin became an uncivilian. Thank you very much. Can I do a short on the R. Kelly verdict? I thought about it. It was on my list of stories. It just became a little bit old. But it's going to be almost certainly consecutive with his other sentences. So he's going to be in jail basically till he dies, I think. We want Lecter. Yeah, so the trial's kind of boring because they already found him liable. Well, they already found him liable in this trial, too. They defaulted him in this trial, too. Sounds like I'm pulling bong loads. Really? Okay. $20 from Michael Palmer. Thank you for being you. Thank you very much. I appreciate that. Am I still doing the cases one? You mean, am I still going to do historical cases? Yes. Like the Great Case? Yes. I need to talk with Rob about that. I need to talk about when to do that and see if I can do it after his thing on Wednesday. Dark Logic gives $20. Would love to see you cover ex parte McCardle, where jurisdiction was stripped by Congress. That can be cool. It sounds vaguely like a water bong, but ain't bubbling liquid. There's bubbling liquid? What bubbling liquid is there? There's bubbling liquid? Well, I'm drinking from the bottle. Okay, that makes sense. That makes more sense, okay. When I drink. Okay, that makes sense. Sounds like the AC is on. The AC's on a little bit, yeah. Not to worry. When I post these tomorrow, I'll massage them a little, and hopefully the AC noise will get reduced. But it's very, very small. It's very, very slight. Can I explain why the judge in the Parkland case was so angry with the defense? I thought the judge's reaction was pretty moderated, actually. I mean, I understand the judge's irritation because, like, it wastes time. It's a good microphone problem. Yeah, there's definitely that for sure. All right, I'm going to sign off for now. Keep that AC on. I need to under that hat. I'll tell you what, it gets a little warm sometimes. I'm going to sign off. Am I still keeping tabs on the Sam 7M versus KJ case? Yeah. I'm still keeping tabs on it. I'm going to sign for now. As always, I hope all is well. Cheers, my friends, and goodbye. Check my Twitter. What is this? Some sort of doc for Daybell info? Maybe I'll take a look at that. Alright, thank you very much for sending it. Where was I? Okay, I'll talk to you later. Bye.